Good morning and welcome, everybody. It is Sunday, May 3rd, 2026, and this is Sunday Funday from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Thank you all so much for being here. Nate Dogg is in the house, Afton and Rosie, Chicago Marie, Heather Coopersmith, Shy Gal, VWRMT says, hey, hi, CC crew, mods, and Josh. Best way to spend a Sunday morning. We're so glad that you were able to make it. Hello to Janelle Rodenbaugh. I think I got that, Mark. Good morning. Corey Curious Kim says, good morning, true crime fam. Good morning, right back at you. I'm so glad that so many of you were able to make it this morning because I think we have a really fantastic bunch of questions that you all sent in. So thank you so much for participating, and thank you so much for being here, and thank you so much for saying hello in the chat. So many familiar names and some new faces and names. Let me introduce myself to everybody who's new. My name is Joshua Ritter. I'm a former prosecutor with the LA District Attorney's Office. I was there for slightly over 10 years before I left to go into private practice as a criminal defense attorney. We started this channel, Courtroom Confidential, with the goal of presenting to you both sides of the courtroom, both sides of the stories, both sides of the issues, and we hope that we do that. And this is a show that we call Sunday Funday because it's on Sunday, and we take your questions that you've left us in voicemails throughout the week, and we are going to answer them live this morning, and we've got a bunch of very good ones, as I said earlier. Hello to everybody watching on Facebook or on X. If you're there, say hi. Always love to see those comments. Please stay to the end. We do have some great announcements for you. That's all I got. Should we get into it? No, we shouldn't. First, we should take a big cleansing breath because you've made it. It's Sunday. It's the end of the week. It's the beginning of the next, depending on how you look at it. Either way, you're here, you're alive, you're happy. Forrest Nelson has been a member for 18 months, everybody. Happy Crewversary. Says, subscribe, hit the like button, share, comment, and chat. It's free to do, and it helps with the algorithm. It does help with the algorithm, so we appreciate you there. Plus, it's free, it's tax-free, and the government won't know about it. I promise you that. You guys came through. Oh, hi from Ireland. Hello there. You guys came through today. We had a lot of really fantastic questions. As always, if I wasn't able to get to yours, please don't take it personally. Please don't be hurt. We try to get to as many as we can. And if I missed you this time around, just ask me a question the next time around. Should we jump into this, ladies? I'm getting thumbs up. All right, let's do it. Where does our first question take us?
Hey, Josh, Tiff, CC crew, mods. I hope y'all are doing well. This is Allie B from Tennessee. I have a random question. I really enjoy it when the jury does jury questions, like the judge allows them to ask questions after each witness. So what is the rule? Do you know, is it by courts, by state, or how is that determined on whether or not the judge will allow jury questions? Thank you so much, Josh. Have a blessed day.
Allie B from Tennessee. Love to hear from you. Let's put Tennessee on the map. And a great question to kick us off this morning. Questions from the jury. I am split on this one. I'll be honest with you. Allie says she enjoys it, really likes to hear it. I can understand that when you're watching, finding out what the jury is thinking about and what they're curious about is helpful to all of us. But I will tell you, as the attorney sitting there, it is nerve-wracking, and I'll get into why. But first, let's answer your question as to why. What are the rules on that? Well, as far as I can tell, there are no rules against it. It's really a jurisdictional decision, and like you said, even a court-by-court decision. I know that I have, here in Los Angeles, had trials where the judge will allow jurors sometimes, if they want to, submit questions. I've watched trials in other jurisdictions where it's almost like part of the trial. It's encouraged. The judge will give them little slips, and after every single witness, they all submit their questions, and then the judge goes back through it, figures out which ones they're going to ask, which ones they're allowed to ask. Much of it depends on the rules of evidence. You know, if they're asking about a piece of evidence that has already been ruled inadmissible, they're not going to get into that. My problem with it, so the answer to your question most directly first is it depends on the judge. It depends on the courtroom kind of practice. It depends on the jurisdiction, but I don't think there are any rules in the law against it. Why am I bothered by it as a trial attorney? Because so much of what you're doing, you're trying to present a certain narrative, a certain story. And when jurors start to ask questions that tend to go on a tangent, it begins to, I feel like you start to feel like you're losing control of the trial. I've had judges ask questions. Talk about a situation where you really feel like the wheels are coming off when a judge starts asking questions at the end. Because you're very careful, you're very strategic on how you're asking questions. Now, listen, the ultimate goal is to get the truth, right? I'm not afraid of that. But I also know that, you know, sometimes with perhaps a particular witness, getting them across the finish line may have been a task in and of itself. And now if you start throwing random questions at them, who knows what might happen. But if I'm going to play devil's advocate against myself, I think it's also helpful to attorneys if they're trying to understand what the jurors are concerned with. I will tell you, one of the most frustrating things is when you're at the end of a trial and then you get a question from jurors and you're like, I never thought they were even concerned with that. We never even thought that was an issue. We never even addressed that in the trial because that wasn't important to our game plan or our vision of how the case should play out, but maybe it was important to jurors. I guess where I would fall on the whole thing, and I know this wasn't really your question, Allie, but I'm going to answer it anyways. I guess where I would fall on the whole thing is if it was helpful in getting the jurors to understanding the case, I can understand it in a limited context. But when it becomes a free-for-all where jurors are just kind of conducting the questioning themselves, that could be a problem. I hope that makes sense. I hope that kind of explains to you why I'm a little hesitant about it, why it makes me sweaty in the palms to think about jurors asking questions, or the judge, or anybody but the lawyers. Maybe it's just me in not being used to it. Maybe if I were in a jurisdiction, if I were raised in a jurisdiction where it was more normal, I wouldn't have a problem with it. But Allie B from Tennessee, great to hear from you. Great question. I'm sure a lot of people have been wondering that. And I imagine we will be seeing more of it in different trials. All right, let's keep it rolling here. Where are we off to next?
Hello, Josh and the crew and everyone in the chat if this is on live. I don't use my real name on the internet, so you can just call me Echo. I am calling from somewhere I believe you have never had a caller from, Ankara, Turkey. And my question is about precedent. I believe it was in the Korovichin's trial where the judge said, let's take a 5-minute break. And then when they all came back, he said he found precedent for whatever it was. And I wonder, how did he find it? Like, is there a system? Do you enter keywords to search? Like, is it expected that you just know all these cases and all these decisions made in them? Does this apply if the precedent was in a different state or if it was a federal case? I know those were a lot of questions, but I'm really curious because precedent isn't very common in our system. So thank you and happy Sunday.
Echo calling from Ankara, Turkey. And you are absolutely correct. That is our first caller from Turkey, and I love it. Thank you so much, Echo. I love that name too. It makes you sound like a hacker from one of those 90s hacker movies. Echo, thank you so much for putting Ankara, Turkey on the map and for being a first-time caller. We appreciate you. New country, slap it on the map. And it's a great question too. What is precedent? I love these questions that ask about something that sometimes I take for granted that everybody understands. And we throw these terms around like precedent, like case law, like stare decisis. All of these are kind of in the same playground as far as the question we're going to be answering here. So precedent, the concept of stare decisis is the idea that, how do I do this simply? Okay, I'm going to try to do this quickly. You have two ways of making laws in the United States. You have a statute and you have the common law. A statute is a law written by the legislative branch, Congress. Congress comes out and they say, murder is bad. We're going to make the taking of another human life illegal. The unlawful killing of another human being with malice aforethought is illegal, is what they write down. Okay, great. That's a great law. Now we have to decide, what does that exactly mean? Well, what does a human life mean? Okay, does that mean somebody born or unborn? What does unlawful mean? What about if the state is putting that person to death through the death penalty? Does that make it unlawful? How about if it's self-defense? Is that unlawful? Malice aforethought. What does malice mean? What does aforethought mean? All of these things are not explained in the statute by the legislators. So we have a long history in some cases of common law, is what we call it, where those questions have been presented before a court. Somebody somewhere along the line had to decide what premeditation means. And then we have a long history of cases, Supreme Court cases in many instances, telling us, what does premeditation mean? That becomes precedent, because now next time you go to argue in a court, what does premeditation mean? You go, well, according to U.S. versus Ritter from 1973, precedent means X, Y, and Z. That becomes the law. That becomes the common law. And there are incidents where maybe courts have to rethink that. So a lower court, a trial court, doesn't have the power to overrule precedent, but a appellate court or a superior court can rethink it. And that happens sometimes, where old law becomes bad law because they've overruled that precedent. But for the most part, the precedent sets the standard as far as our interpretation of the laws themselves. I hope that makes sense as far as understanding what precedent is. Precedent is just an established common law ruling on what the statutory law means. What does it mean when you're talking about a reasonable person? What does it mean when you're talking about circumstantial evidence? What does it mean when you're talking about the surrounding circumstances? All of these little terms that we throw around, somewhere along the line, some court has had to tell us what exactly is meant by that, because maybe a very nuanced question on that has come up. So how do you find all of this? Well, I'm so old that back when I went to law school, even though we did have things called computers, they taught us how to find case law through books. Books are things, Kaylin, that are printed out and they are hardbound, and you open them up and you read them. We had to literally, you would look up in indexes, let's say you're looking for premeditation. You'd look up and it would give you all these cases on premeditation. Then you go back and find those cases. Oh, you need to go to 23 U.S. 451. You ever hear them give a citation in court? Well, that's the 23rd volume of U.S. case law, section 4, case number 431. Then you have to find the page number that they're talking about. Then it gives you a definition. And you do all of that today, but they do it through computers. There's two big platforms that make that abundantly easy. One is called Westlaw and the other is called Lexis. And it's also been so long since I've had to do this personally myself that I don't know which one is more popular. They go in and out of popularity. And they do all that work for you. You just now, it's almost like doing a Google search. What is precedent? And you get 5 or 6 different cases pumped out to you that give you the definition that you can cite in court. But the other thing you have to do is what's called shepherdizing, because what if that case has been partially overruled on some grounds or completely overruled. Now it's bad law. You can't cite it anymore. You have to find a more recent case, the case that overruled that case, to cite in court. All of this comes down to what exactly you're allowed to cite as precedent from the case law to a judge to argue your point. So when you're talking about Miranda versus Arizona, I can't remember I think it's Arizona versus Miranda. You have to make sure that Miranda is still current law. Has it been overruled to some extent? Has it, have they changed the view on some of the things that Miranda may have stood for? I feel like I could go on and on about this forever, and I think I'm starting to lose you because I'm starting to lose myself. But I hope that all makes sense, that it is a lot of what lawyers do as far as law in motion work is finding cases that are on point, that are convincing to their argument, and that have not been overruled and are something that they can bring up in front of the judge. And a lot of time is spent on finding those things. Nowadays, it's much easier with the computers, but it's still basically the same process that's taking place. Thank you so much, Echo, from Ankara, Turkey, putting Turkey on the map, now on the Courtroom Confidential 2027 tour. All right, let's keep it rolling here.
Hey, Josh and CC crew, it's Farm Girl from Ohio. Josh, just wondering if you see any holes in this Aaron Spencer case that could really cause some trouble for him. I personally think that most people are going to hear the basics of the case and be like, not guilty, but who knows? So just curious your thoughts. Thanks. Have a great day. Bye-bye.
Farm Girl from Ohio, let's put you on the map. Thank you so much. Always good to hear from you. Always good to see you in the chat. Aaron Spencer, when is this coming up for trial? I should have put this in my notes. I know it's coming up quickly. There he is, running for, actually now just received the nomination, at least from, I think, the Republican side for sheriff in that county. His trial's coming up in June. We will be following that one. Hopefully that one will be cameras in the courtroom. If it is, you can be sure that we're going to stream it for you. Just to catch everybody up really quickly. He is accused of murder, June 22nd. There you go. He's accused of murder of a man named Michael Fossler. Michael Fossler was a man that had allegedly SA'd his young 14-year-old daughter, Aaron Spencer's 14-year-old daughter. He was given bail, shockingly. While out on bail, Aaron Spencer wakes up in the middle of the night to his dog barking, goes into his daughter's room and finds that she's not there, calls 911, gets the police involved, says, my daughter has been gone and I think I know who did it, goes out in his truck, tracks down Michael Fossler, forces him to pull over, gets him out of his car at gunpoint, and according to Spencer, or the reports that we've read at least, says that Fossler lunges at him and he fires upon him. Now, I explained that in about as brief a manner as I did to anybody on this planet, and they're usually going, why in the world has this man been charged with a crime? Why aren't they giving him the keys to the town, to the city, and holding a parade in his honor? He sounds like he's a hero. He sounds like he saved his daughter's life. He sounds like he saved his daughter's life, or if not as bad as that, from future harm for certain. By the way, Fossler, even according to those facts, was already in the midst of another felony, kidnapping. Okay? Perhaps other horrible stuff, but at least at the very minimum, kidnapping. And there is a very righteous, I think, argument to be made for self-defense here. What holes could there be? Well, we're going off of the evidence that we have. I will say, whenever you're talking about self-defense, it's going to come down to reasonableness. Did you perceive the threat to your life or the life of another person reasonably? Did you respond? Was your response, the use of deadly force, reasonable? And did you use a reasonable amount of force in response? What are we talking about? If you're talking about a person who gets into a bar fight and somebody punches them in the face, and then you pull out a gun and shoot them several times, that might not be perceived as all that reasonable. But in certain circumstances, maybe it can. Maybe that person is pummeling you and you're near death before you start to use a gun in response. It's a very fact-heavy inquiry that needs to be taken by the jury. So the facts of this case are going to become incredibly important. One of the facts of this case that is troubling to me for Aaron Spencer is the amount of shots that he fired. I think they said that it was somewhere in the realm of 11. I can't remember the exact figure. You guys probably know. But I remember thinking that it was probably the entire magazine that his gun held, his handgun held. So he unloaded his gun. That's going to become a question for jurors. Was that a reasonable amount of force to use in response? Now, I can already hear the arguments of people saying, of course it was. The guy was kidnapping his daughter. He was perhaps lunging after him. There are also reports that he refused to get out of the car, refused to let her out of the car. All of this stuff plays into the surrounding circumstances of what would be reasonable. And the reasonableness standard is what would a reasonable person in Aaron Spencer's position do or perceive. I mean, the other argument that could be made is I see somebody put up 16 shots, 15 hit Fossler. There you go. So he was probably carrying a high capacity magazine inside of his gun and unloaded on him. I don't think that indicates reloading. If it does, probably further problems for Spencer. But you could also say, well, maybe the threat wasn't neutralized from Spencer's perspective. You could also argue, listen, it's not the amount of shots, it's the fact that he shot at all. And if you feel that he was righteous in shooting at all, then counting the amount of shots isn't really what we're here to talk about. You know, I mean, the other thing, we could talk about all the other surrounding circumstances. Was Fossler actually a threat? Was he lunging at him? I think where prosecutors are coming from in this case is that they may have felt that Fossler took the law, or that Spencer took the law into his own hands, and that they don't want to encourage vigilantism. And I get that. But I also don't get charging a man with murder in these circumstances. The fact that this hasn't settled in some sort of way, that they haven't given him some sort of, negligent discharge and he gets, probation and no jail time is a miscarriage of justice in my view. Maybe there are facts about this thing we just don't know. But from where I stand and the facts that I do know, I think this is getting dangerously close to being a miscarriage of justice. And I think you kind of already seen that from the way that the Supreme Court in Ohio has handled this. They removed that judge. They put a new judge in. They've opened up the courtroom to cameras. They've done a lot to try to shed some light on this thing because I think they know people are very troubled by this. And of course, we can't leave without showing my boy with his turkeys. Look at that guy. That's a guy I would like to sit down and have a beer with. That is not a man that I think belongs in prison. And I'll tell you what, I could easily see myself being in his position if something like that were to happen to one of my girls. So I applaud him. I don't think we should be jailing him. Thank you so much, Farm Girl. I hope that answers your question. Heather Coopersmith, thank you so much for the super sticker. So kind of you. Lindsay Brillhart says, you're not old, you're young at heart, Josh. Oh, well, I appreciate that. Thank you so much. Love at CC. We'll love right back at you, Lindsay. And Best Nancy, thank you so much for supporting us with the membership. All right, let's keep it rolling here.
Hi, so my name is Fatima. I am in Mar Vista, a little town in Los Angeles. And this is my first time calling in, and I'm feeling a little nervous, but I'll do it anyway. Josh gets really amped up every time he talks about the Crumbley case or anything regarding that idea where parents are being held responsible for something that a child has done. I completely understand the anger and the frustration that comes with that because it could be a slippery slope and whatnot. But I was wondering if, Josh, you've ever heard of the Firearms Control Act in South Africa, where the idea is if your gun is stolen or if you have not put your gun in a safe place or in improper storage of any kind, if someone takes your gun and murders somebody with it, then you can be charged for that murder as well, if I'm understanding it correctly. But I feel like we're kind of going in that direction and we just need a law that solidifies it in a way that makes more sense for people. But just curious about that. Love to hear your thoughts on that law in South Africa.
Fatima from Mar Vista, California. There we go. Putting LA County on the map. Thank you so much, Fatima, for calling in. Me get worked up? Not me. Me get upset? No. I will say, let me be more careful in how I explain my frustration, if you even want to call it that, when it comes to cases like Ethan Crumbley, like Colt Gray. I share the incredible frustration and despair that I think we all feel about this epidemic of young people and committing great acts of violence at their schools in particular. And every time one of these happens, I feel like we all collectively, our hearts break a little bit more, and we all immediately start to go, why can't we stop this? What can we be done? And you have people who kind of run to their respective corners, and there's people who say, well, we need more gun control. And then there's people who say, well, no, we need to, in fact, what we need is the teachers to be armed. And, or we say more needs to be done about mental health, or more needs to be done about, gun safety. And I'm not trying to pitch my position on any of those things. And I'm certainly not trying to make this political. What I am trying to do, though, is say, okay, I understand prosecutors. And I, in fact, encourage and applaud prosecutors who think outside the box and are trying to be aggressive in protecting their communities. And these prosecutors have said, listen, we're not just going to hold the actual shooter responsible. We're going to hold the people who allowed for that situation to take place to begin with. So Ethan Crumbley is the one who pulled the trigger, no doubt. And Ethan Crumbley will spend the rest of his life in prison, rightfully so. But they look at mom and dad and say, yeah, but you could have done more. And you knew enough to have done more, and you didn't. And that's where we are holding you responsible. Now, where I start to get nervous is when you say, fine, holding you responsible, but holding you responsible for what? For the negligent parenting, for the negligent securing of a weapon inside of your home, all of those, sure, because those are things you did personally or did not do personally. But then holding that person responsible for what Ethan independently did, that's where I start to get nervous, because he independently, they didn't know he was going to do that day. He went out and took the gun unbeknownst to them. I think they even believed, or they had it in a safe. It wasn't properly secured, but he went and got it out of there, snuck it to school, didn't tell them what he was up to, committed this incredible atrocity. And what I fear is that many people go, well, I don't care. And I get it. Like, I don't think there's a lot of people losing sleep over the fact that the Crumbleys are in prison. But where I get concerned is where are we drawing the line? Is the line now, as Fatima suggests, maybe more in line with this Firearms Control Act out of South Africa? No, I wasn't aware of it. I had to do some research about it. And I'll be honest with you, much of it is very similar to the laws that we have here. They have age requirements for possessing a firearm. You can't be old. You have to be older than 21. You have to be a citizen. You have to have a stable mental state. Do you know those same rules apply here in the US? If you're under any kind of mental health care, you're not eligible to purchase a weapon. Narcotics convictions, any kind of felony convictions, you must complete a test. You must do training. Many states have these same laws in effect. California certainly has these same laws in effect. But what they do, and I wasn't able to find much on this, but we'll go with what Fatima is telling us, is that if you do not properly secure your weapon and somebody takes it, even steals it, and you don't immediately report that as stolen, and somebody goes out and commits a crime of violence, that you can be on the hook for that. And that is, it sounds great, right? Because we want to encourage people to lock up their weapons. It sounds great, but you're also talking about putting people in prison for murder, for something they did not do. What the Crumbleys did was be awful parents. What the Crumbleys did was not secure that weapon. What the Crumbleys did was not get their kid proper mental health or take it all seriously. But what they didn't do is pull the trigger. But what they got convicted for were the murders as manslaughters, but responsible for the deaths of those people, those children that lost their lives. When you think about it in those terms and try to remove emotion from the whole thing, it becomes a little, you become a little uneasy is all I'm saying with that. But listen, if we came out with a law that said you can be held liable, criminally liable, if you do not properly secure a weapon, I'm all for that. But if that liability then extends to the actual murder, really got to think about this kind of stuff because it can have unintended consequences. Thank you so much, Fatima. Thank you for being a first-time caller. Always appreciate that. Thank you for being part of the conversation and all your support. And Ann Potter, thank you so much for supporting the mods with coffees. Appreciate that. Hey, it's Dr. Patrice Berry is in the house. Hello, glad to listen. She's super juiced. I'm going to have to ask her about this, the psychology of all of this at some point. And Fuzzy Buzzard, I love that name, Fuzzy Buzzard. Could you please explain why sometimes a person will plead guilty, but still there is a trial? Apologies if this has been addressed. I just don't know. I think what you're talking about is the situations where there's a trial on the penalty phase, which we have seen a couple of times in the last few years. Most recently, now there's a ongoing case out of Texas, really awful. Nicholas Cruz out of Florida, he pled guilty to the actual murders, but went on trial for the penalty phase, which was basically to decide the death penalty or life without parole. That is where you see it most often. But you can in other types of bifurcated cases where it's a NGI, let's say. Lindsay Clancy was trying to do that out of Massachusetts, but they didn't allow her. But that has happened in cases where anytime you can bifurcate a trial and you're saying, I want to take the guilt phase out of it. I want to take the question of guilt or not guilt out of the hands of the jury and just get the jury to decide something like, was this person insane at the time? Or should this person receive the death penalty? Those questions alone in front of the jury. But great question, Fuzzy Buzzer. But it can lead to almost what appears to be a full-fledged trial. The issue with the case is that he had significant mental issues and they bought him a weapon and didn't restrict access. The parents also seemed more interested in their own stuff, in my opinion. I agree with you. I completely agree with you. I completely agree with you that they didn't do all those things. They bought him a weapon. They didn't restrict access properly. They knew he had significant mental health issues. They didn't do enough about it. They were far more concerned with their own lives than they should have been with their very troubled young son. But they didn't pull the trigger. And they didn't know he was going to pull the trigger. And they didn't drive him to school and tell him to go pull the trigger. And that's where things start to get a little murky. Where was I? Thank you so much, Fatima. All right. Let's keep it rolling. Get it together, Ritter. You got a long day ahead of you.
Hi, Josh. My name is Wendy. I'm from Central Newfoundland, Canada. I was wondering if there was any new updates on the Tepe case and the Reiner case. Everybody seems to be talking about Nancy, Guthrie, and David, but I haven't heard anything really about the other cases. I never catch you live, which is sad, but I hope to one day. Have a great day. Thank you. Bye.
Wendy, I hope you're here today. Wouldn't that be great? On the day that we're going to answer your question. Wendy from Central Newfoundland. Newfoundland or Newfoundland? Oh, and I think you're the first caller from that area too. So thank you so much, Wendy. Can we zoom in? Is it Newfoundland or Newfoundland? I think it's Newfoundland. Either case, you're on a big old island all alone there, Wendy. We hope that we can get you some friends from the CC crew. But thank you so much for being a first-time caller, for calling in. Yeah, these are two cases that we've been following very closely. Newfoundland. There you go. These are two cases that we've been following very closely. No, that's right. You got it right. I think so. I mean, last thing we need to do is turn this into a geography show as well, but I think you got it right. Oh, there you go. Hi, fellow Canadian Newfie. Is that what oh, I love that. Newfies. We love you out west. Oh, thank you. All right. See, Newfie. Okay. All right, here we go. What is happening with the Tepe case and with the Reiner case? First of all, the murder of Monique and Spencer Tepe took place on December 30th of last year. The man arrested was Monique's ex-husband, Michael McKee. The latest on him is this is going to be one of those things where it kind of drags on for some time, and that we'll give you updates where we can, but it does not seem to be in any great hurry to get to trial. He was in court actually a couple weeks ago, April 16th, for a status conference, and they put nothing on the record. They just asked for additional time. I think this is one of those things where it's going to drag on for some period of time as they gather discovery, and then all of a sudden we'll see a bunch of activity. At the prelim, certainly at the trial, but it's going to be one of those things that it will kind of be a slow burn that we'll continue to update you on. I will say, though, and I think we talked about this, or if we didn't, I'm glad that I have an opportunity to talk about it now. There was a lot of buzz going around the internet that he was going to plead not guilty by reason of insanity. That is coming from nowhere. That is coming from a report done by News Nation, I believe, that spoke to an expert who's not connected to the case, some talking head who said there's a possibility that could be a potential defense raised. His attorneys have not said that. No one in court has said that. There's no indication of that. But people took that article and then ran with it as if that's going to be his defense. I think News Nation could have been a little bit more careful about the way that they kind of titled or portrayed that article that they released, or that report that they did. But I'll tell you this right now, there's no NGI coming out of this case. The amount of planning that this man put into it, the fact that he had to travel several hours, went out there once before, the constant stalking, the planning, the use of a silencer, the way he was able to get into the home, all of this man, there's no NGI here. There's no NGI here. Does that mean they won't try it? They could try it. I don't think a judge will allow it. I mean, remember, a judge has to allow that defense. And you don't get to have this much premeditation and planning and then say, well, I didn't know what I was doing at the time. Not going to work. Not going to fly. And then Nick Reiner, speaking about NGI, he is accused of killing his parents, Rob and Michelle Reiner, on December 14th of last year. Exactly. No expert would claim he was insane at the time of the offense. Thank you, Dr. Patrice Berry. He was last in court a week ago, April 24th, for a prelim setting is what they call it. So he hasn't had his prelim yet. So we're all in that kind of setting period. This one is probably going to go on for a period of time. The latest, what is NGI? Not guilty by insanity. Not guilty. Sometimes you see it as NGRI. Where I comes from, we say NGI. Now, Reiner, many people think he is going to plead NGI. We will see. I think this is probably far more set up for that, given his history of mental health issues, that he was actually diagnosed with it. That's an important part of it, that he was actually under the care of a psychiatrist, being prescribed medication for it. All of that seems to be lining up, but they haven't even indicated that that's the defense that they're going to make. This case is also dragging on. The autopsy reports have not been done, which is shocking to me. We're now several months out, and the autopsy on these is, as horrible as they are, the autopsies, I imagine, are fairly straightforward. We understand that it was, some sort of stabbing or some sort of use of a knife. I don't think that involves, this is not a out of ordinary sort of an autopsy that would take this long, but they're not done. That's according to the prosecutor from the last time they were in court. They also have a tremendous amount of discovery, 2 terabytes of discovery that they're turning over to the defense. The next court date is September 15th. You heard that right. And that is not the prelim. That is just another setting date. This one is going to drag on, unfortunately. But thank you, Wendy, for bringing up those cases. Always glad to give us updates on things that we've been following closely and care a lot about. So I appreciate you calling in from Newfoundland, Canada. All right. Just keep it rolling.
Hi, Josh and CC crew. This is Dawn from Fairfax, Virginia, also known as Two Dog Mom on the chat, period. This is about the Lynette Hooker disappearance. The U.S. Coast Guard and Bahamian police are investigating her disappearance. If they find probable cause that Bryan was involved in her disappearance or murder, who would try the case? If Coast Guard took the lead, who would try the case and where would it be tried? Bryan just hired a lawyer in Michigan. Would she represent him wherever the trial would be held? Thanks for your input. Really appreciate it. Have a great Sunday, everybody.
Dawn from Fairfax, Virginia. Thank you so much, Dawn. Let's put Fairfax on the map. Here's another case that we're following closely that we're not getting a lot of updates. And it's tragic and sad. We're not even getting the idea of if they've even considered this fully a crime yet, by the way. Yeah, I know they've opened it up as a quote unquote criminal investigation, but that doesn't mean that they necessarily feel that. I have not heard a report where a law enforcement official has said, we believe foul play took place. I have not heard that. I know they've interviewed him. I know they've held him. I know that they were very kind of tongue-in-cheek about not saying that he's a suspect, that he's just being held for questioning, which is something that you can do in the Bahamas. But I have not heard someone officially involved in this case say, we believe this is a crime, not an accident. That has not even been determined yet. But let's say that they get there. Let's say that they find out they do make an arrest. Bryan is arrested. And again, I've said this so many times. I feel awful, and I'm trying to be as balanced about talking about this case as I possibly can. But I would feel awful if this was a tragedy and an accident and this man lost his life in this horrible, horrible way, and we're all talking about him as if he's already convicted. So this could be an accident. As far are there surrounding circumstances that are highly suspicious? Sure. But are they beyond the realm of credulity? I don't think so. I mean, do people fall off of boats? Sure they do. He fell off of a boat, by the way, when they arrested him. Do people get swept out to sea? Unfortunately, all the time. Do weird circumstances sometimes all conflate together? Do they all come together at the same time? Sure. Doesn't make the man guilty. Does it mean that we should raise our eyebrows and ask a bunch of questions? I think absolutely. Questions are nothing wrong with those. Nothing wrong with trying to get to the bottom of something. But you know, God forbid we're going after a man that lost his life and on top of that, everybody's going after him. But okay, putting all of that aside, let's say in a hypothetical, he is arrested. Where are they going to prosecute this case is what Don wants to know. Well, Don, that would kind of have to be something worked out between the governments. The Bahamas have certainly jurisdiction. It was a crime committed in their waters, in their territory. That is something that falls squarely within the purview of their ability to prosecute. But because it involves American citizens, the U.S. federal government can also get involved. And they have before. And they've extradited people or they've charged people for crimes that were committed abroad. They wouldn't, if he's still in the U.S., that might kind of determine it too. If they arrest him here in the U.S., you might think that it would be more efficient to just prosecute him here rather than extradite him back to the Bahamas and rely on them to prosecute him. I have a feeling that if he is arrested and he's in the U.S. at the time of arrest, it will probably remain within federal jurisdiction and they will probably prosecute him here. And if his attorney in Michigan wants to represent him, that's fine. If he gets arrested down and they bring him back to the Bahamas, he'll probably need to get local counsel. He already had an attorney down there. Yeah, listen, if we get a break in this case like that, we're going to be talking about all sorts of stuff like this. So this is one of those things that's going to have a lot of legal kind of curlicues to deal with. Thank you so much, Dawn from Fairfax, for asking the question and keeping us updated on that case. Heather Cooper-Smith, thank you so much for the super sticker. So kind of you. Appreciate your support. Odell Burgess, very kind of you, says thousands of people suffer from mental illness and most of them do not commit heinous crime like Nick Reiner did. That does not excuse him for what he did. You are preaching to the converted, Odell. I get it. And by the way, that is not, and it's a great question because that is not the definition of insanity as far as from a criminal perspective, from a legal perspective. It's not just you had a mental illness. It's that you had a mental illness and that caused you to be unable to appreciate the consequences of your actions, that what you were doing was either morally, ethically, or legally right or wrong, that you were just so untethered from reality, you couldn't appreciate that. That's going to be the problem, not the fact that he had a mental illness. They might even concede he had a mental illness. It was well established. But did that cause him to be able to not be able to appreciate what he was doing was right or wrong? That's a much more difficult hurdle. And I think, just the small amount that we know from this case, somebody who flees from the scene, goes to another location, cleans up, and then leaves that location seems to me to be indicative of somebody who knew what they just had done was a bad thing. Thank you so much, Odell. And happy crewversary to Eatery Terry Cat, who is really super juiced. Oh boy. Peony D, 47% juiced. Come on. Cheryl, 21% juiced. Intuitive Karen, 23% juiced. There we go. Hippie Mimi is 71% juiced. Afton, 78% juice. I like this. Now we're getting I see what you're doing, ladies. And then you bring me back down. Kaylin, 38% juice. Kaylin, when the girls are misbehaving, Tiffany's 4% juiced. When the girls are misbehaving, we put them in the thinking chair, and that's a chair that they have to sit in and think about what they've done until they're ready to apologize, and then come back and behave and be good listeners. Kaylin and Tiffany are going straight in the thinking chair when this is all done. Same to Crystalline, 58% no. We only take A pluses here at Courtroom Confidential. All right, hush up. Get on with it, Ritter. Nobody wants to hear this. Therapist you know is 100% juiced, according to therapists you know. That's okay. I'll take it. All right. Where are we at here? Hold on.
Hi, Josh, Tiff, Caitlin, CC crew, and all the new members. This is Little Miss Red Velvet from Manchester. This is about Bryan Kohberger. His defense lawyer Ann Taylor's statement regarding Dr. Brett Turvey, who was a defense expert, talking to Christopher Whitcomb, who is a retired FBI agent who has written a controversial book. Dr. Turvey signed a confidentiality agreement. What are the rules around these, Josh? Do they differ state to state? Is there more than one version of a confidentiality agreement? Look forward to seeing you all on Sunday Funday. Take care. Bye.
LMRV from Manchester, England. Always puts me in a good mood to hear from you. Thank you so much. Let's put Manchester on the map. Talking about Bryan Kohberger in the latest with this expert, Dr. Turvey. Dr. Patrice Berry wants to know about this too. So we went into this in depth with Kevin Fixler. You guys all remember him when we used to give you your regular dosage of a Fixler fix. This was just last Friday, just a couple days ago. We talked about this on our weekly roundup. Did a long interview with Kevin where we got into this whole thing. So I encourage you all to go listen to that, because Kevin does a really good job of breaking it down. But I'll give you the short version of it. Is that, yeah, the defense and Taylor had hired this expert, Dr. Turvey, who was kind of a forensics expert. That I imagine it sounds like what they wanted him to opine on was the idea of whether or not more than one person could have been involved in the murders. And that if this had gone to trial, he may have been called to testify to that. But he went way beyond all of that in kind of his thoughts, and very vocal now thoughts on the case. He has criticized Ann Taylor. He has criticized the defense. He has said that there's problems with chain of custody when it comes to the knife sheath. The part that really got me is he's kind of incredulous over the idea that Ann Taylor didn't explain to him to his satisfaction why Bryan Kohberger took a plea. Here's the answer to that. None of your business. Bryan Kohberger and Ann Taylor had a discussion, and that ended up with him making the decision to take a plea. Explaining it to you is not important to any of them. And so if you are not satisfied, sorry, move on with your life. But more importantly, probably maintain some sense of decorum when it comes to, I don't know, throwing your entire employer and defense team under the bus. And that's what he's done. And so Ann Taylor came out with a scathing statement on this. She hasn't said anything, by the way. And it was interesting to talk to Kevin about this, because he has reached out to her several times to ask for statements since the case is closed. Her client's been sentenced. He's off to prison for the rest of his life. She is more than available at this time to sit down for an interview, but she won't do it. Not that I don't think he wasn't trying to imply that she's being rude to him at all. But he's reached out to her several times for comment and she won't do it, which is her prerogative. She can do that if she wants to. But he said it was shocking to him then when he opened up his email and there was an email from her, and in it was this statement that she released where she talks about how this guy, Turvey, violated a confidentiality agreement. But I will tell you, it was probably far less about the confidentiality and much more about distancing herself from this campaign that this doctor has gone on. And I think fully hanging him out to dry for any future employment. You imagine if you're a defense attorney and you find out that a guy that you're looking to hire tried to torch the defense team because he didn't like how things played out after the fact, you're never hiring that person. You kidding me? So that was the latest on this LMRV. It's all kind of it's not going to no, you didn't miss you. We're talking about you right now. It's all kind of a bunch of kind of gossipy stuff surrounding the case that doesn't have an actual effect on the case. But it was kind of important enough that we felt that it was necessary to get into. So please check out that episode with Brian Fixler. We were talking about the murder of these beautiful 4 kids from Idaho. Kaylee Gonzalez, Madison Mogan, Zaina Canodal, and Ethan Chapin. All right, let's keep it rolling here.
Hi, Josh. This is Jerry Michael again in Newport News, Virginia. I'm watching the Julio Foolio murder trial, and my question is regarding leading questions that I keep hearing the defense object to, that the prosecution is asking their witnesses. Can you explain exactly what leading questions are and why that is an issue during trial that the defense objects to? Thank you.
Jerry from Newport News, Virginia. Let's put you on the map. I know that the audio was a little difficult to hear, so I'm just going to recap what Jerry asked, and we appreciate you, Jerry, for calling in. She was asking about, not really about, but she was saying that she's been watching the Julio Foolio trial. This is a trial that's taking place right now. It's for 4 people are on trial for murder out of Florida for the murder of Julio Foolio that took place back in June of 2024. It's currently underway, and she's been watching it. It's a case that we have not followed all that closely, not because we don't think it's important, but because there's just so much to talk about and so much to cover. But during this trial, there's been a lot of objections regarding leading questions, and she wants to know what is a leading question? Why is it an issue? Why does it keep coming up? Leading questions have to do with the difference between direct and cross-examination. On direct examination, you are not allowed to ask leading questions. On cross-examination, you are, which is why there's an advantage to taking a witness on cross-examination. You will sometimes see attorneys try to strategically cross-examine, find an opportunity to cross-examine a witness that they might have needed to call on direct themselves. Or why you will see in rare instances where an attorney might say, Your Honor, permission to treat the witness as hostile. All that means is, can I cross-examine this person? Can I ask them leading questions? And that's really the advantage of cross-examination. Well, what's the difference and what is a leading question? A leading question is a question that suggests the answer. So, after you heard the shooting, you ran to call 911, correct? I've suggested the answer. That's where you'll hear in leading questions and on cross-examination, many of the questions will end with correct. And in fact, if you're doing cross-examination well, you're almost exclusively asking leading questions because you want only yes or no answers, because with a leading question, you're allowed to far more specifically control the examination of that witness, because all you're allowing them to do is answer your question. After you heard the shooting, you ran outside, correct? Correct. And after you ran outside, you ran into person number A, correct? Correct. Whereas on direct, you can't do that. You can't suggest the answer. So you have to say, after the shooting, what did you do next? And that's where it becomes a little more laborious and like pulling teeth sometimes, because it will take a person it will take them on a much more circuitous path to get to where you want to go. And it's a little bit more difficult. Now, why do we only allow that on cross and not on direct? Well, the idea comes down to, if you're calling a witness, we want unbiased, uncoached, undirected testimony from that witness, if it's your witness. But if you're cross-examining that witness, we want to give you the ability to not allow that person to just run amok and run wild with your questioning. So you're allowed to be far more controlling of that witness, because it's not your witness. It's not, the idea comes down to whether or not that witness might be friendly to you. If that witness is not friendly to you and you have not called them as your witness, we're going to allow you a little more control over that witness. But if that witness is friendly to you and you have called them on direct, then we're not going to allow you to have as much control. And we want kind of more unfettered honesty coming out of that person. I hope that makes sense, but those are the rules of engagement, and that's what leading has to do with. So you'll hear the objection only if somebody's being examined on direct examination. And it's difficult, you end up with, in the hands of less skilled attorneys, a lot of questions that are like, what happened next? What happened next? I always like to kind of do what they're called, I forget how they referred to it, but it was like wraparound questions, where I would kind of include everything that they had told us up to that point. So after you were inside and you heard the shooting, and then you said you ran outside, what did you do next? And it kind of is a way of like sort of getting the person down the path that I'd like them to go. Didn't always work. People like to talk. All right. Thank you so much, Jerry from Newport News, for asking that question. Appreciate you. Thank you, Heather Cooper Smith, for the super sticker. So kind of you. The Crafty RN says, show some love for ad-free lives and make Tiff happy. Oh, that does make Tiff happy. Yes, we appreciate your support. We have dedicated ourselves to always bringing you, if you're watching us live, this is what we've said. If you are going to take the time to watch us live, then we are not going to allow that to be interrupted by YouTube. And we've kind of made that a dedication for ourselves here at Courtroom Confidential. So that's why we appreciate all your support and generosity. And Tiffany says 260. That's quite a heavy lift there. 260 more likes gets gifted memberships. All right. We can do it. We got a little more show to go. 260 more likes. All right, let's keep it rolling. What if we get 500 more likes? Then what do we get? All right, where are you at here? The spinning wheel of death. What's happening? Here we go.
Hello, CC crew, Josh, Tiff, Kel, mods, everybody. I'm so happy to be part of this community. This is Alitude calling from Bunkerville, Nevada, first-time caller. My question is regarding the extradition of Ivan Miller in the triple murder case in Wayne County, Utah, that happened in April. last I heard, he is, Colorado is actually not sending him back to Utah because Utah is death penalty state, and he could be charged with the death penalty for the triple murders. And Colorado won't send him back because of that. I don't know if this is actually true. So my question is, how does that work? What's the process to get him back to Utah so that he can face these charges for just so brutally killing these 3 women for really no reason but to steal their car? Thank you, and happy Sunday fun day to all. And I hope I'm awake and watching with you. Bye.
Allison, are you awake? If you are, let us know. From Bunkerville, Nevada, first time caller. I don't know why my heart is warmed by all the first time callers. I guess because that means you guys have been watching and you've been liking it and you've been involved in the chat, and now you've decided to take that leap and go ahead and participate in the conversation. And I know it's not easy, and I know it can be a little nerve-wracking sometimes, but I love to hear it. So thank you, Allison. First-time caller, Bunkerville, Nevada, asking about a case that this is another one that is kind of on the radar, but we haven't been following all that closely. Really horrific, senseless, as Allison puts it. There's a reason behind it, but not a reason for it. Ivan Miller killed 3 women in Utah, and here's what led to that. First of all, he got arrested in Iowa for burglary, and he gets pretrial release. And if I can take a moment, whenever you start to hear debates about bail and about pretrial release and about how, why are we keeping people locked up when they're pending trial? This is why. There are dangerous people out there who do incredibly dangerous things. And yes, they do them even while they're on pretrial release. So he's granted pretrial release. It was a burglary. I think he had a weapons possession at the time. Never should have been a person walking the streets. He gets pretrial release. And he decides to just take off. And he gets in his car and he's driving through Utah, and he runs into an elk. This is part of the story. Totals his vehicle. So now he doesn't have a car and he's still on the run. He hides out, I think, in the like a shed connected to this woman's home. And then when she leaves, he's hiding out in her home. And when she returns home, he kills 86-year-old Margaret Oldroyd. Sweet old lady, doing nothing. Didn't do anything to him. Didn't harm him. Was randomly selected by this psychopath. Why? Because she had a vehicle. So he murders her and takes her vehicle. Could he have just stolen her car? I suppose so. But he decides he needs to kill her. So he murders her, takes her car, drives off, and then decides he needs a different vehicle. Unclear as to if he just ran out of gas or wanted to throw people off his trail or whatever it is. But he runs into Linda Dewey, age 65, and Natalie Graves, age 34, who are out on a hike. Not bothering him, just randomly selected people, kills the 2 of them, and steals their vehicle before he is finally arrested in Colorado. And that's where Allison's question becomes pertinent. Murders are committed in Utah, 3 of them, 3 women killed for no other reason than he needed a car. Again, could he have accomplished the theft of their vehicles without murdering them? I'm sure he could have, but wasn't good enough for this psycho. Gets arrested in Colorado, and he is fighting extradition. Now, to your point, Allison, I have not, in my research into this, found anything about the state of Colorado fighting it because of the laws in Utah. And I know that that is sometimes raised as an issue about whether or not some states have the death penalty, some states do not, whether or not those states will extradite to those states, depending on whether or not they seek the death penalty. I will tell you, I've heard of that, and I can't remember the last time I've actually seen an instance of that taking place. And you're saying that you've heard reports of that's what's happening here. I didn't run across anything like that. All the reports that I read said that he is fighting extradition. And maybe what you're hearing is that he intends to make those arguments as some sort of desperate attempt to fight extradition. But I think it's going through the normal course of extradition. Utah has not, but is going to file a motion to have him extradited. He will be extradited. I mean, there's no way this ends up with him not getting sent to Utah to face these charges. Now, whether that means that some sort of agreement is entered between Utah and Colorado and regarding the death penalty, I don't know. The idea that all these crimes were committed in Utah and he just happened to get arrested in Colorado, you would think Colorado would just say, listen, handle things as you feel appropriate. We're just going to go ahead and extradite him. But I haven't heard what position the respective states are taking on that. His next court date is at the end of this month, May 28th. So we'll continue to keep an eye on this one. Just really senseless, horrible stuff. This kind of stuff just, all of this is horrific, but these types of things where it wasn't, you see stuff for money, for kids, for all sorts of horrible reasons, but this is just, it was easier for me to pull the trigger than to not, is what this one comes down to. Thank you. Where are you at? Allison from Bunkerville, Nevada. Debbie Harrow, thank you so much. Says, miss you guys live. I always watch replay though. Well, you're here live now, I'm guessing. Thank you so much, Debbie Harrow. Appreciate you. Appreciate your generosity. Gina Gilmore, thank you so much for the Courtroom Confidential memberships. I hope everybody who receives one of those enjoys them. And Debbie Harrow, again, happy crewversary. Congratulations on being nominated at CrimeCon. Thank you so much for that, Debbie. I'll talk more about that at the end of the show. But yes, we have some special news to share with all of you that we're very excited and honored about. All right. Let's get to it then, you all say. Well, then get to it. You are here. Good.
Hey, Josh, this is Chris Vogt from Crossville, Tennessee. Just got finished watching the replay of your Wednesday Night Live with Mr. Quealy. Awesome guest, by the way. But I just kind of wanted to dig in on something that came up near the end of that interview. First, that brief was just, horror show stuff. And the fact that David had somehow managed to fly her out of the country to London to meet his family. A, how did his family not clock how young she was or question how young she was? And B, how on earth did he get her out of the country without her guardian's permission? Because presumably her parents weren't in the know on that, I would think. So yeah, just curious if you have any more thoughts on that or how that might have come about. Crazy stuff. Thanks.
Chris from Crossville, Tennessee. Thank you so much for calling in, Chris. Appreciate you. Let's put you on the map, Crossville, Tennessee. So thank you so much, Chris, for watching our shows on replay. And I want to thank all of you. I appreciate that support when you guys aren't able to catch it live, but you go back and watch it anyways. We love the support and we put a lot of work into these things. So we would hope that you would catch them even if you can't catch them live. This was a really fun interview with James Quealy. He's an investigative reporter. He has the crime beat here in LA for the LA Times. And he's been following both the David case and the Nick Reiner case very carefully. So we're going to continue to bug him as these cases continue to develop. But one of the questions that has come up several times is that when you read the prosecution filed basically a preliminary hearing brief where they just kind of talked about rough sketches of everything that they've got in this case. And it was mind-blowing. So please watch that episode to get caught up on all of that. A lot of interesting evidence and facts, and you certainly have a better understanding of how they've arrived at the charges that they filed here against David. But kind of in the details, not really highlighted, they mentioned that she, Celeste, had traveled with David to different locations, Las Vegas, Texas, and London. And a lot of people said, wait a minute, London, England? How in the world did he get this girl on a plane to London, England? Now, I know that some people have said astutely, well, isn't there a London, a smaller kind of unincorporated community in Texas called London? There he goes. Okay, this is what people are saying. So I wanted to get to the bottom of this. London, Texas. I see everybody saying this. There is no indication that that's what they're talking about, London, Texas. I asked James about this. Has he heard anything about this? Now, he has not obviously spoken to the prosecutor, Beth Silverman. She's not going to be talking about this, but maybe she will realize there's some confusion and give some clarification on this. So, end of the day, I am not saying I have a definitive answer for you on this, but there is no more indication that this is London, Texas than London, UK. And I will say, if it's London, Texas, it would be a very bizarre way of writing this brief to just throw in London as if we all know what they're talking about being London, Texas, not London, England. And in the paragraph, she mentions Texas as being like another location. It was like Las Vegas, London, and Texas, which wouldn't make sense that you would say a city in Texas and then also include Texas. Okay. The other part about this is we do know she had a passport. Why do we know that? Because it was recovered by Caltrans in the Santa Barbara area. He had made trips up to an area in Santa Barbara and disposed of some evidence along the State Route 154, and a Caltrans employee, these are people who are involved in the maintenance of the freeway system, found her passport. So she had a passport. Okay, so there's either the theory that this is London, Texas, or there's the theory that this is London, England, and she had a passport. That then raises the questions of, how did he get her on that plane? Well, either her parents signed off on it, or he fraudulently signed whatever documents might be necessary to secure that visa for a young person, or no one just checked. She had a passport, she had a ticket, and she got on a plane with him going to London. I've seen some people suggest a private jet. I don't think this guy was that big of a deal that he's flying private. Could be, but just some, up and coming, viral singer. I don't know if they're throwing that kind of cash at this guy just yet. And again, you still need a passport to enter another country, even if you're flying private. And I imagine they're still concerned with trafficking of young people in those types of situations. Just might make it a little bit easier. The end of the day, there's a lot of unanswered questions, and specifically about this. But you raise even another question, Chris. What about his parents? They said in that brief, she went with him to meet his parents. Now, we know his parents are from Texas. Why aren't they asking questions? What are you doing with this child, David? She was 14 years old. She was actually much younger when they started their relationship. I think he met her at 11 and started a sexual relationship with her. And I only use that term relationship because I can't get more graphic on YouTube, but started abusing her at 13. His parents aren't going, "What, David, what are you doing? Who is this young girl? Who is this child that you're with?" And do her parents know she's here? Lot of unanswered questions, a lot of things I hope that we'll get to the bottom of. But I will tell you, I reached out to James, and he was under the impression, and he has no further evidence to guide us either way, but he was under the impression this fully meant London, England. And he agreed that like there's not a way of reading that otherwise. Holly says, yes, London, England. David mentioned it in an interview that he loves England. He loves London because it's gloomy. I saw that interview as well. I mean, all of this, we're trying to do our best guesswork. It would have been nice for them to be a little bit more clear in the brief, but hopefully we'll be finding out exactly the details on this to come. But I will say she had a passport. So, all right. Thank you, Chris. Let's keep it rolling here. Elger 1972 says, quick question. If there's a deadline for the DA deciding whether or not to pursue the death penalty on DA Burke, on David Anthony Burke. Okay. There is not a deadline, but they have to decide before a certain amount of days out from the trial. And I forget what that is, but it's not like they have, X amount of days from filing the charges to decide, but they do have to decide in X amount of days before he's brought to trial, if that makes sense. They're probably not going to decide on this one for some time, though, because it's I know that they were all quick to rush to prelim, but as predicted, that is all kind of gone out the window now with the terabytes, 40 terabytes of information they're going to have to go through. I imagine this will drag on for some time, and they will probably make a decision on that, within the weeks following the conclusion of the prelim. Potentially criminal. Hello, my friend. Says, I get the feeling we're going to find out that Celeste's parents were getting paid to not report him to the cops. The fact that they never had charges filed is very concerning to me. A lot of criticism has gone the way of the parents, and I get it. A lot of, I think, very legitimate questions as to what was going on in this young person's life and why were their parents allowing a 13-year-old to fly around the country with this man. I don't know. I don't know the sophistication level of the parents. I don't know if the parents were trying and just doing a bad job of it. I know they had reported her missing. I know that she sounds like she was a very willful young woman. And you also have a situation where he was working behind the scenes against them. I mean, we now know, even according to that brief, that he was paying, the parents took away her phone. They were trying, right? He paid some kid $1,000 to give her a phone. He was getting her to come out from where she lived in Lake Elsinore by paying for Ubers to drive her out. I mean, this man was a predator. And I don't know, could the parents have done more? I think we're all sitting here asking the same questions. I don't know, but great question, potentially criminal. Appreciate it. All right. Where am I at? You guys are having a good time? I feel like we've had a lot of great questions. I was very impressed with the questions this week, but I was also impressed with the fact that we were, for first time in Ankara, Turkey, and for the first time in Newfoundland, Canada, a lot of first-time callers this week. So thank you guys so much for being part of the conversation. All right, where am I at? Here we go.
Hi, Josh, Tiffany, Caitlin, and mods. This is Ann Jones from Mishawaka, Indiana. And my question came from the David hearing, asking for, or the prosecutor said that they were going to do a minute order. What is a minute order, and why do they call it a minute order? Thank you, and have a great day.
And I hope you're having a great day. And from Mishawaka, Indiana, let's put you on the map. Where is that? That right in the middle there? Mishawaka, Indiana. Thank you so much, Ann. What is a minute order? again, one of those things that we kind of throw these terms around. I take for granted that you all know what we're talking about. A minute order is an order made by the judge in court that is not a formal order signed. So in other words, many times you will ask a judge you'll make a motion that the judge orders something to happen. Your Honor, we want you to order discovery. And you might include in that an actual unsigned order. And then the judge, when granting that order, will sign that order. And now you've got a piece of paper in your hand that is the order. So if let's say, here's a better example. Your Honor, we want you to order that the police department to release the defendant's cell phone back to him. Okay. Defense team goes in. They make their argument. The judge says, I think you're right. I'm going to grant that order. The judge signs that order. Now you take that physical piece of paper and you go back to the police department and you say, give my client back his cell phone. Or there is no paperwork and it's an order argued in, or it's an issue order argued in court, and you ask the judge to just issue an order. Now there's no paperwork, so the judge is doing this according to the minutes. The minutes are, back to the days of when we would literally have a court clerk writing down what the events of what was taking place in court, taking the minutes of what was taking place in court. You've got the court transcript. You've got a stenographer who's sitting there writing down everything that everyone is saying. But then you've also got the court clerk who's writing down like what is taking place as far as orders being made, new dates being set. So they're taking the minutes and they're actually still entering this stuff into a computer, the minutes of what took place. When is the next court date? What did the judge order? So if the judge, in the case of David here, the last minute order I think you're referring to is that they asked that the autopsy report be unsealed and that the judge make an order of that, a minute order. So the judge ruled from the bench, I order that this be unsealed. Now what that prosecutor can do is go up to the clerk and go, can I get a printout of the minute order? And they'll literally print out a piece of paper that has the minutes of the day, including that order, to bring to the coroner's office to say, go ahead and unseal the autopsy. So it's just another way of getting business done outside of the courtroom. I hope that makes sense. Anne from Mishawaka, Indiana. Appreciate you calling in. Deep breath, Ritter.
Hi, Josh and CC crew. This is Carrie from Phoenix, Arizona. My question today is regarding the role of an investigative grand jury. I know you've explained the process ad nauseum, so I apologize for this, but I still have one lingering question. So for example, in the David case, if the DA was using the grand jury as a means to only compel witnesses to give testimony and not to seek a decision on an indictment, did the grand jury members simply sit there and listen to the witnesses being questioned with no active role? I've just been wondering this. Thanks for taking my lingering question. Have a good rest of Sunday Fun Day.
Carrie from Phoenix, Arizona. Let's put you on the map, Carrie. Investigative grand juries. A lot of people have had questions about this because we don't see it all that often. Where you will see it is where you don't hear about it. They take place all the time, but you usually don't know it because that's the nature of an investigative grand jury, is that they are secret. And because they're not returning an indictment, you may not know that they've ever been convened. There are several investigative grand juries taking place as we sit here right now, but you don't know it. I have known, having been in the DA's office, about investigative grand juries on huge cases that never got went before an indictment or never got charged because they're just doing the investigative part of it. I guess the best way to think about this is that in states like California, they don't have depositions. There is no way to compel a person to come and give sworn testimony, but through some sort of mechanism like a prelim where you filed charges. But what if you don't want to file charges? What if you're before the point of filing charges? How do you compel a person to give testimony? You don't have a power of deposition in criminal cases in California, but you do have a grand jury. Well, what if you want to convene a grand jury? You want to subpoena someone to the grand jury. You want them to testify. You want it to be under oath, and you want it to be sealed and secret, but you don't actually know if you're going to get to the point of an indictment. Well, you do an investigative grand jury. You serve them with subpoena. You bring them into court. You ask them a bunch of questions. They're under oath. They're under penalty of perjury. It's being transcribed. You're doing all the things that you wanted to do, but you're not actually asking for an indictment. So Carrie's question, though, is, okay, that's all fine and good, and I understand that, but what is the jury? What are the actual people doing? Are they just sitting there and listening? Yeah. Yeah, they are. And they don't have an active role. No, they're just sitting and listening to the testimony. It's call it archaic, call it bizarre, but yeah, it is the only mechanism to compel that person to testify is in front of a grand jury, and you have to convene the grand jury and all its members in order to do that. Now, that's why in the David case, you've heard them talk about 3 grand juries got convened. Why is that? Because it took place over such a long period of time that the same grand jury who sits for a period of weeks was not able to hear all of the testimony. So they actually had separate grand juries convened to hear all of the testimony in this case. And because you've got separate grand juries, you can't ask one of them for an indictment because they haven't heard all of it. So you weren't using them to indict. You were using them to gather evidence. You were using them for the subpoena power. You were using them to put people under oath. Hope that makes sense, Carrie. It's confusing because we don't see it all that often, because it is a rather clever and aggressive way of doing things. The feds do it all the time. Stateside, they don't do it all that much. Oh, there you are, Tracy. Well, you're very welcome. Oh, wait a minute. That's Tracy, not Carrie. Well, you're welcome, Tracy, and Carrie, I hope you heard. All right, let's keep it rolling. Odell Burgess, thank you so much for the super chat. Says parents can do everything under the sun, so to speak, but if their child wants to do something, regardless of what their parents say or do, they are going to do it no matter what. Well, there you go. And listen, again, it sounds like she was incredibly willful. I don't, listen, they lost their daughter in a horrific way. I will save the kind of unwinding of all of that for a later date, but I appreciate, Odell, exactly what you're saying. Michelle Maskill, thank you for so much for the super sticker. Appreciate you, Michelle. Pixie Dust, thank you for the super sticker. Very kind and generous of you. Oh, we got a 800. Oh, wow. Fantastic. We keep our promises. We'll do it, lady. Did you send out did you? I don't see the proof. Where's the minute order? And case closed. All right. Are you looking for it? I'm going on to the next question. She says, no, I'm not even looking for it. All right. Here we go.
Happy Sunday, Fundy, Joshua, Tiffany, Kaylin, our fabulous mod, CC family, and guests. Felicia K. Mayo in Humboldt, Tennessee. All right, Joshua, since you were psychic and you already discussed and answered the questions I had about Tennessee's slimy little amoeba, Austin Drummond, possibly representing himself, you talked about his rights on Wednesday Night Live, so I'm going to tweak my question. Does Austin Drummond not have the right to ask for a simple change of taxpayer court-appointed attorneys? And if he is granted the ability to represent himself, does he not have the opportunity to ask for a change of court-appointed attorneys as his side counsel? That's my questions. Thank you in advance. Hope everybody has a great Sunday fun day. And while you're at it, having a great Sunday fun day, walk your fingers over there to the like button and press it, because Josh was great. Sunday Fundy is great. Everything CC is great. Thank y'all. Bye.
Gotta love me some AKM on a Sunday morning from Humboldt, Tennessee. Thank you so much. Yes, what is it? The slimy little amoeba from Tennessee, Austin Drummond. Yeah, we did talk about this. I think we talked about it on Friday. It was one of I think it was part of the leftovers from the week, but he is asking the court to represent himself. And I had said he doesn't necessarily have awful arguments on this. His attorneys, it sounds like, have ignored his requests when it comes to some pretty fundamental issues. One of the things that a defendant has sole discretion over is the clock. They're the ones who have a right to a speedy trial. And if they don't waive that right, they are entitled to have a speedy trial. And one of the complaints that he's made against his attorneys is that they have ignored that and they've waived time. And he's saying, enough of this. I want to represent myself. Well, just to catch everybody up, Tennessee has a rule 13, according to the Supreme Court, that the court shall appoint 2 attorneys to represent a defendant at a trial in a capital case, and that they have to be licensed and experienced. But it's a shall rule. The court shall appoint 2 attorneys to represent a defendant at trial in a capital case. But what's interesting about that is, does that necessarily mean that the appointed attorneys have to actually be the operating trial attorneys? Drummond also has a right, according to, okay, so here's an interesting example. We were talking about precedent and common law and statutory law. Well, one of the laws of the United States is the Constitution. The Constitution has an amendment called the 6th Amendment, which grants a defendant the right to counsel. What does that mean? Well, in a series of cases that have followed, according to the common law and now establishing precedent, one of those cases was a case from 1975 called Ferreira versus California. In that case, the Supreme Court interpreted the 6th Amendment. So they're interpreting the law, as we talked about earlier, that if you have a right, it makes sense that you also have a right to refuse that right, to waive that right. So if you have a right to counsel, it only makes sense that you would also have a right to refuse counsel. And therefore, though it's not even written into the Constitution, common law and precedent has established the right to represent oneself and proceed pro se. So you've got the Supreme Court saying he's got the right to represent himself, and you've got the Tennessee Supreme Court saying they have to appoint attorneys. Sounds like the way this is going to work out is he will be given the right to represent himself, but they're also going to appoint attorneys as standby to avoid any issues. But Alicia K. Mayo makes the excellent point. Doesn't sound like the issue is really he wants to represent himself. It sounds like the issue, he didn't like those attorneys. So why can't he get new attorneys? That could be the other way this ends up, and probably the simpler way is you've got a gripe with those attorneys. We'll just get you new attorneys if that's really what the issue was. Because the arguments he made, though they were good, were more about the attorneys themselves than about him wanting to represent himself. We'll continue to keep an eye on it. Very interesting kind of turn of events in a very, very awful case. Thank you so much, AKM. All right. Court Dog Daniel is very kind and generous. Says, Josh, you say valet, I say valet, Raul valet. Could you do your leftover update on the case? Didn't get to submit a voicemail this week. Was at a Red Sox game with my kids. Oh, that's nice. 23 days till Crime Con. Juiced. Oh, that is sad that we're not going to be able to hear that. And I didn't do it justice. What is the update on that case? He has, let me think for a second. his attorneys have made the argument that the double jeopardy should apply. And they are making the argument that the jury's verdict in not finding him guilty and acquitting him of murder and hanging on manslaughter necessarily means that they believed his actions were justified as far as self-defense. And if that is true, then self-defense should apply to everything as a justified action, even manslaughter, and therefore double jeopardy somehow applies. And even as I'm explaining it, you can kind of see the problems with it. Because the jury, we don't know why they hung on manslaughter and why they acquitted on murder, but it's quite a leap to say that the reason they did that was because of the self-defense argument. Because if the self-defense argument had prevailed in their heads, you're right, it would prevail at murder and manslaughter and everything else. I think a more reasonable interpretation is that they had a problem with the intent issue, not the self-defense issue. And that's why they acquitted on murder. They just didn't feel it showed adequate evidence of intent to kill, but there was evidence of intent as far as the lesser required for manslaughter. End of the day, I don't think this is a prevailing argument. They're trying to say that he's been, put in jeopardy once for these crimes, and therefore it should apply and he should be allowed, to walk. I don't think that's going to carry the day. So I hope that answers your question. Court Dog Daniel. Juiced. Heather Cooper Smith, thank you so much again for the super sticker. Very kind of you. Best Nancy, thank you so much for supporting us with the memberships. Let's keep it rolling. Where am I at? Okay.
Josh, it's therapist, Can you walk us through how selecting and retaining an expert typically works in a case, including how funding is handled in situations where experts are court appointed? Who determines prices and how much is too much? And based on that, is it more accurate that attorneys are choosing experts whose perspectives already align with their case, or that experts' perspectives tend to be shaped by the side that retains them? Thank you. Bye.
Yes. I love this question. The answer is yes. TYK from West Texas. Thank you so much for calling in. Thank you so much. Let's put you on the map. Great question. Okay. First of all, what is the process in selecting an expert? If it's privately retained counsel and they're going to be paying for the experts themselves, the client is going to be paying for the expert, then it's whoever you can find and whoever you can afford. And if depending on how deep the pockets are of the defendant, that could be anybody. You could get Michael Bodden if you wanted to. You could go and find the top experts in the field that everybody's heard of and knows about and get them to come into court for you. If you are working through court-appointed counsel or the public defender's office, you still are given the opportunity to hire experts. Those experts, though, have to agree to be on the schedule, the fee schedule per that county, which is not nearly as much as they could make privately, but many of them do take the work because they want to continue to work. So you will have many, many, many experts who continue to get appointed by the state. They're paid out of the same taxpayer dollars that pay for the public defender or pay for the court-appointed attorney, but it's on a schedule already agreed to, usually on an hourly basis, and usually the funds have to be continued to be approved by the judge. So you'll go, Your Honor, I need 10 hours for this expert. Can you approve these funds? The judge will sign that. And then maybe the expert needs more time. You have to go back and ask for more time. Sometimes judges say, no, that's enough. That's plenty of time that has been allotted. Usually they do it because it's reasonable. They don't run out of it, run out of funds. That would be a real bad situation if somehow an expert is not getting paid. And I don't know what they would do. Honestly, I don't know if they would compel that expert to come in and testify anyways. I don't know. But the question that you asked that I really like is, and usually this is when we're talking about the defense, because the prosecution's experts are usually the coroner, the police involved. You know, they're the people who kind of work for the government anyways. Private experts, rarely hired by the prosecution. Do they seek out experts based on their opinions? And do the experts give testimony favorable to the employer? Yes. Yes. Listen, I'm not going to dance around it. Many times these are hired guns. I mean, yes, you are. Here's a perfect example. A very in vogue, and I think it still is, type of expert is an eyewitness ID expert. If you've got a case where your client is the biggest evidence against them is eyewitness testimony, and you got nothing else to go on, you're going to try to attack the eyewitness testimony. So there are plenty of experts who operate in the field of eyewitness testimony, and they talk about things like weapons focus, that no one can remember what the face of the person looked like when they've got a gun pointed in their face. That's weapons focus. Cross-racial identification. It's hard for people of one race to identify a person of another race. There's on and on and on and on. And these people work in this field. So you hire that person, and that person adapts their testimony to the circumstances of your case to testify to those things. And yes, they know who they're getting paid by. They know they're not going to come in and say, no, I think this is a really good eyewitness ID. That's why I say many times when we be careful, tread lightly when relying or putting too much weight into the opinions of experts, because that's exactly what they are opinions. They are not evidence. The evidence is a witness says this person did this crime. That's the evidence. The opinion is, were they in a good position to give that testimony? Were they in a good position to make that ID? And you can go to any situation where there's an expert. You can do that with the medical examiner. The medical examiner is giving an opinion on what do the injuries on that person, a slit throat, a stab to the chest, a gunshot wound to the head. That's the evidence. It's the medical examiner's opinion as to what caused death and was this a homicide or not? And you can go out and hire another medical examiner who might have a different way of assessing all of that, but it's their opinions. It's not the actual evidence. Great question. Therapist, from West Texas. I appreciate you asking that because I feel like it cannot be understated enough. Sky Goddess, thank you so much for the super sticker. All right. Michelle B, thank you so much, says, hey there, Josh. Can you please bring back Matt Murphy as a guest soon? Yes, I will. He's a very busy guy. If he'll pick up the phone, I will do that. And Heather Cooper Smith, thank you so much for the super sticker. All right, guys. Get out those tissues. It's down to the last three. Who's bringing us home?
Hi, everybody. Happy Sunday Fun Day. So I'd like to take a moment to acknowledge Josh for being absolutely 100% right and doubling down and being right. Now double down again. So we're going to see. I bet you're going to be right again. You told them, sir. That's all I have to say. So after that, here's one more thing. So David's lawyer, I forget her name, but I'm sure that nobody else has. I'm having one of those moments. But anyway, Blair Burke, there we go. So anyway, Miss Burke, according to other people, other talking heads for that matter, are saying that she will not be the one who ends up prosecuting or defending this case in the long run. She didn't know about the C-SPAM, and that freaked her out. Plus, now she doesn't really have a chance to win. And so she's probably going to bow out. That is what they're saying. Knowing what you do of the people involved in all of the games that people play in LA. Oh, that was a rhyme. What do you think? All right. Thank you. You're the best. And you were right. Josh was right, everybody. Okay, bye.
Thank you, Sonia. Sonia from Chicago, Illinois. Let's put you on the map. Yeah, we're talking about the David case. What Sonia is talking about is I was adamant that they were going to waive time, that there was no way they were going to head to prelim on this within the 10-day period. And I said, just you wait. Just you wait. This game of chicken's going to end pretty soon. And it did. And they asked to put the time over. I forget. I think they're coming back at the end of this month for another status conference. The prelim is not going to happen relatively soon on this. If my guess is right, 40 terabytes of information, 3 different grand juries. I mean, this is just a lot of very dense information for them to get through before the prelim. Okay. But your question is, one of the new revelations is that there was CSAM material, CP material found on his devices, and that the rumor is caught Blair Berg off guard, and now she might not want to be involved in this case. One, I will say this material, every indication is what this material is related to Celeste. So I don't want you guys to get the misimpression that somehow he had a bunch of exploitive material involving other minors. Maybe, but I think what they're talking about here is it was mainly dealing with Celeste, explicit photos of her, videos, things like that, which is CSAM material. Absolutely. Will it change whether or not Blair Berg wants to represent him? I can't speak for her, but I seriously doubt it. I'm sure that she was probably had her head wrapped around the idea that there was a illegal exploitation by her client taking place of this young lady. I wouldn't even be surprised if they concede that. I mean, listen, if they're trying to keep him out of murder charges, if what's left is the idea that he was conducting this exploitation of a young girl, and that's all that's left, I'm sure they would concede that. And that's probably how this ends up, as sickening as that is that they say, listen, yes, he was doing this. Yes, he was involved in her. They were in love, ladies and gentlemen, but he did not kill her. I think that's the way this whole thing goes. So I don't know if it's going to get her to withdraw. There's plenty of reasons for her to find an excuse to withdraw. I mean, it could just be he runs out of money at some point. But if you're asking my kind of inside feeling on this whole thing, I don't think so. I think that she probably got hired knowing what she was definitely up against, knowing what the charges could be, and she's probably in it for the long run. But don't be shocked. You know, we've seen stranger things. You know, Alan withdrew from Nick Reiner relatively quickly, so stranger things could happen. Thank you, Sonia. Julie, thank you so much, says, watching from Switzerland. I love that. And hope Rosie gets a gift membership. Hit like button, please. Thank you so much, Julie. Appreciate you, and appreciate you and everybody in Switzerland who might be watching. Michelle B., just a little thank you to you and your crew for choosing great topics, and looking forward to some Matt Murphy. Hopefully Joseph Scott Morgan was brilliant. One of your best episodes. He's brilliant. Thank you. And Matt and Joseph Scott Morgan will also all be at CrimeCon. So check them all out there, everybody. And Heather Cooper Smith, thank you so much for gifting the membership. Very, very kind and generous of you. All right. Who do we got next here?
Hi, Josh. This is Dara Kaplan calling for the second time from Washington, D.C. First off, I want to say that this format is fantastic. I look so forward to Sunday Fun Day. I think you're so personable and you make all your callers feel important and special. I really appreciate that. So my question for you, I've always wondered about this. How does it work as a defense attorney? What is your position with your client as their defense attorney? And do you defend clients even if you believe they're guilty? Do you build your case around the evidence that the prosecutor has, or do you have to go with what your client tells you? Really curious about this. How does it work? Thank you so much. Love your analysis. Talk to you soon. Bye.
Thank you, Dara, for the very kind words. That's very sweet of you. I appreciate that. Calling from Washington, D.C., right in our nation's capital. Appreciate that. A defense attorney colleague of mine who's been doing this for much longer than I have, once when asked a similar question, had said that he views himself as being, as a defense attorney, involved in law enforcement because he's enforcing the laws against the government. And I like that. I like that way of thinking about it, that we're all involved in law enforcement, whether you're on the prosecution side or the defense side, and I've been on both. But it is true. As a defense attorney, I think that your job is to enforce the laws. You're just making sure that those laws are being followed by the government and by the police and by the prosecution, and that they're not trampling all over the Constitution in their pursuit of a conviction. And that's, I think, the best way for a defense attorney to operate, because if you are operating under the idea of all my clients are innocent, you're not going to be very successful, because there are many people who need an attorney who have done something. Now, did they do exactly what the government is accusing them of? Many times, no. Did they do something that they're probably most likely going to be held responsible for? Most times, yes. Listen, I mean, if you think about it, that is the way it should work, right? I mean, there's a big problem if people are out there hiring attorneys and the majority of those people are innocent people. There's a huge breakdown in our system if our courtrooms are filled up with innocent people. Even the trials are filled up with innocent people. This is not a game of did they or didn't they when it gets to court. The vast majority of the time. Is that ever true? Of course it's true. Have I handled cases where people are flat out innocent? Absolutely. And it is nerve-wracking. I've never experienced the kind of stress that I have sitting next to a person that I believe to be completely innocent and sometimes accused of something really horrible. But most of the time, that's not the way it is, and that should be the way it works. We have so much of our system is set up to prevent against that. The laws of the Constitution, the protections of due process and probable cause, and all of these big terms that we use and throw around are all to protect against innocent people being charged with crimes and being brought to trial. So, yes, as a defense attorney, you are many times defending people who are quote unquote guilty. But what are they guilty of? One, and what price should they pay? Two, many times clients come to me and are freely admitting they did what they're accused of doing. They're just saying, hey, help me to get out of this in some sort of way that allows me to move on with my life. Yes, I'm willing to take responsibility, but help me get out of this in some sort of way that I can still have a future. That's mainly the job that you spend most of your time doing. A small fraction of your job is in court battling it out on a case where you feel like you're defending an innocent person. And to your other question, do you build your case around the evidence or what your clients tell you? You should build your case around the evidence because that's what the tools that you're going to have in court and what you're going to have to argue. Does your client sometimes add to that or give you insights into that? Sure. But if your client is, telling you in the face of overwhelming evidence that, they weren't there or they didn't do it, you're going to have problems defending that person to their satisfaction. And as a private attorney, I can sometimes sniff out those problems from a mile away. I hope that makes sense. Dara, it's a great question. A lot of people are curious about, but that's kind of the reality of it. So I hope that gives you some illumination on it. All right. Court Dog Daniel, there he is. Best community in true crime, folks. Drink it in. Drink it in, he says. Happy crewversary. Michelle, thank you again, says, who else loves it when Josh says, okay, where am I? Always working hard. He's always lost too. And Ali Foley, thank you so much, says, motion to have Dr. Patrice on the show. Granted, if she's still here, we're gonna bug you soon. Keep your phone on the ringer on. All right, everybody. This is our last question. I know. Who's bringing us home today?
Hi, Josh and CC family. Tim is my name from Melbourne, Australia. I was going to say one of your dudes, but in fact, bloke is a more common term over here. That's spelled B-L-O-K-E. So I'll go with one of your blokes. My question relates to over-explainers, meaning perpetrators who go into great and often irrelevant detail when interviewed by police at a time when you would expect that their focus would purely be on helping authorities find their missing loved one or otherwise find out what just happened when their loved one has been harmed. We saw Brian Walsh do this when interviewed by police while his wife Anna was missing. We saw Alex Murtagh do this when police spoke to him immediately after he claimed he just found his wife Maggie and son Paul murdered. And we saw Caleb Flynn do it when calling 911 and then speaking to police while claiming an intruder had shot his wife Ashley. According to reality monitoring theory developed by Marcia Johnson and Carol Ray, truthful memories contain sensory detail linked to experience such as feelings, what they saw, what they smelled, etc., whereas lies often overload with irrelevant detail because they believe detail equals credibility. My question is twofold. To what extent do law enforcement train their teams in these sorts of psychological theories to help them potentially spot people who are being dishonest when interviewed? And secondly, to what extent could it be useful for a court to hear from an expert in this field during trial? That second one may not be a thing. Look forward to hearing from you. Thank you.
Tim from Melbourne, Australia. One of my blokes. I love that. This is now a new thing. One of my blokes calling from Australia. Thank you so much, Tim. And Tim, what a fantastic question. I'm so glad that we're ending today on this question. Really well put together. Talking about, I love this term that you use about how lies are often overloaded with irrelevant detail. And isn't that true? There's something about us as human beings where we can kind of sniff out the BS. And one of those things I think is realizing when a person is overloading us with irrelevant details. There's something about a person having genuinely experienced something that you could just tell that from somebody who's making it up on the fly. But as far as being able to detect that, being able to sense that, being able to articulate all of that, that is well above my pay grade. But luckily, I don't have to do that because I can always phone a friend.
Hey, Tim, Greg Hartley. Great question. And anytime you're talking about training for any department, it's all over the board. Some of these people will spend the money and the time. Some people will read on their own. So I'm not going to jump ahead and tell you exactly how many departments will actually do any of this kind of thing. In all my years of being an interrogator, teaching interrogation, teaching resistance to interrogation, I'll tell you that everything humans do is a process. And quite simply, what you're doing is looking for the cues to that process. What I think you're seeing when you see all these details is a person who's deconflicted their story to the best of their capability. Doesn't mean they've done a great job, because people think of holes in their own story, and those holes in their own story are what they bring up. A great example is if you go listen to 911 calls, you can almost always tell that perpetrator is the person on the phone because they give you too much detail and they're establishing an alibi as they tell you a story. There's actually a study called "The Caller is the Killer." Eventually AI will pick up a lot of this stuff. But I published a few years back a thing called The Liar's Loop with Scott Rouse, and The Liar's Loop quite simply says there's always a process to a lie, and that starts with a trigger. That trigger event can be something that just happened now and I have to lie about it to cover it up, or it can be something happened 10 years ago in the case of a cold case. When that person has that trigger event, then they have to fabricate information, and they're going to fabricate that information through lots of different ways. Sometimes it's omission, sometimes it's commission, sometimes it's embellishment, sometimes it's transference. Once they do that, then they deconflict that in their head, and what you're hearing when they give you all those details is a deconflicting about what they think is wrong with their story that you will be able to pick apart. When you're interrogating prisoners, you listen for stress on those words because it tells you where they think they have a problem and you go after it. Once they deconflict it, then they have to pitch it. They have to tell you what the answer is. When you answer with a question, now they have to defend that. And if you do it right, you'll force them back into deconflicting, pitching, defending, until you get into what we call the death spiral of a lie. And in effect, the best indicator a person is being deceptive is often they're forthcoming with information that has nothing to do with what you're thinking of, because they're deconflicting the holes in their story and telegraphing it for you. Hope that helps. Tons more where that came from. Thanks.
That guy is so brilliant. Like I could listen to him all day, and as every minute passed, I feel dumber and dumber, yet somehow more and more educated. Thank you so much, Greg Hartley. That is Greg Hartley from the Behavior Panel here on YouTube. There's his Instagram, his X, his Facebook. Please follow him. Please say hello. Please, next time you're on their channel, send them some juice boxes to tell them how much we appreciate. But what a great answer to the question too, Tim. I hope that was enlightening to you as it was to me. And if you want to hear more, first of all, I love what he said about the death spiral. I just watched this video the other day. Have you guys heard this about carpenter ants? That there's this horrible phenomenon that will take place with carpenter ants where they are nearly blind. And so the only way that they are able to track each other to find food sources is from their own scent. So one ant will follow the scent of the ant in front of it. But there's a bizarre phenomenon where if one ant gets lost and off the trail, the other ants could start to follow that ant. And as that first lost ant tries to find its way, it can find the tail end of the other ants. And before you know it, they're going in this circle. They're going in a death spiral, they call it, and they will literally do that. It's like a mass extinction for the colony. They will literally do that to the point of exhaustion because they don't know where else to go. That's just kind of an interesting aside, but I thought a great metaphor that he uses there about people caught up in a lie and a death spiral of their own lie. If you want to hear more, we sat down in one of our conversation series with Greg Hartley. We interviewed actually everybody from the Behavior Panel, but every one of these conversations is fascinating. His in particular is phenomenal. I encourage you all to check it out. It's on our channel. We'll send you, make sure that you have the link, but like I said, I could listen to those guys all day long. It's fascinating stuff to me. Something I wish like in another life I had more time to train myself on. And there you go, Tim. Yes, it is something that hopefully investigators learn more about. Prosecutors, I will tell you, don't get any training on it, and they probably should. But even could you call someone like a Greg Hartley to the stand to talk about the defendant, if the defendant testified? And that is a interesting question, because I don't know if a judge would allow it, because essentially, if I'm the prosecution and Caleb Flynn testifies and tells this nonsense story, could I call Greg Hartley in my rebuttal case to talk about what a liar he is? I think you could call him to generally educate the jury on how liars lie, but you could not call him to call Caleb Flynn a liar, because that would be an ultimate question for the jury on whether or not Caleb Flynn's a liar. Isn't that interesting? maybe a judge would allow you to call an expert to say liars, overload with irrelevant detail and all of the stuff that Greg just laid out. I would love to see that. I would love to see that. Thank you so much, Tim, one of my blokes from Melbourne, Australia, for bringing us home today. Court Dog Daniel, one of my dudes, says, as soon as I heard CC Bloke's question, I thought of Behavior Panel. Brilliant dudes. CC has the best connections. Oh, we'll appreciate that. We do, and we have an incredible community of people. And we got to 1,000 likes, everybody. Now what, Tiff? How are you going to match that? Afton, thank you so much for gifting the memberships. Appreciate you, Afton. Farm Girl, thank you so much for gifting the memberships. You guys are all so kind and generous. Appreciate you today. All right, let me get you some announcements and get you all out of here. First, really quickly, please check out our website, thecourtroomconfidential.com. And the reason why I want you to go there is not just because we're very proud of it and we put a lot of work into it, but because you're going to find some things like, one, if you listened to the questions today and you thought to yourself, I loved them, but I want to ask my own question, you need to go to thecourtroomconfidential.com and click on leave us a message. And that's how you can leave a message for next week's Sunday Fun Day. 2, membership. A lot of people received gifted memberships today. Thank you, everybody, so much for the support. If you didn't get one, but you want to be part of the crew, then click on join, become a member, and find out about all the benefits of membership. And 3, merch. We have... What do we got, Kaylin? Fire them at me. Show me what we got, Kaylin. We've got quarter zips. We've got tumblers that don't come with the stuff inside them. You got to provide that yourself. We've got hats. We've got notebooks. We've got t-shirts. And in fact, speaking of t-shirts, we've got hats. One of the t-shirts that we have available now to everybody is this wonderful t-shirt that I'm wearing today. It's our co-branded t-shirt for Courtroom Confidential and CrimeCon coming up this May 29th through 31st in Vegas. And it's now available both black and white. Where's my white version, by the way, ladies? For everyone to pick up now at the shop there you go. That's what it looks like at thecourtroomconfidential.com. All right. What did you miss this week? Well, we had the roundup, like I said, with Kevin Fixler from the Idaho Statesman. We talked about Bryan Kohberger. We talked about Matthew Farwell, Aaron Spencer. That's all up on our channel now. Then also on Fox Nation, I do a show alongside Paul Morrow and Donna Rotuno called The Weekly Rap Sheet. We talked about the shooter from the White House Correspondents' Dinner. We talked about Matthew Farwell. Please check us out at Fox Nation. We have a brand new Instagram and X accounts. The handle is at Weekly Rap Sheet, where you can leave us comments and questions. And I've bugged the folks over at Fox Nation, and they are running a special because they are the exclusive streaming service for CrimeCon. So if you are not able to make it to CrimeCon, I completely understand. Fox Nation is streaming CrimeCon for you. They're the only ones doing it. So I don't know if it's every single speaker, but most of them are going to be streamed live cameras from CrimeCon. And they're running a special for 50% off an annual subscription with the code CrimeCon 2026. So enter that code at checkout to get 50% off of Fox Nation. We hope that you check it out. And while you get your Fox Nation, you could also watch the rap sheet. All right, coming up next week, stay tuned on our sister channel, CC Live Trials. You have to subscribe over there. It's a separate channel. We are going to be streaming the Brendan Banfield sentencing. That is going to be this Friday at 11 a.m. Eastern. There you go. Please check that out. CC Live Trials. That's our sister channel for all of your streaming desires. Then on Monday, live at 5 p.m. Pacific, 8 p.m. Eastern, we're going to be right back here talking about what all the news that you would expect to talk about in true crime coming up for the week. And again, we're back at it Wednesday for Wednesday Night Live at 5 p.m. Pacific, 8 p.m. Eastern. Race and Rodeo, thank you so much for becoming a YouTube member. Kimology and Callie, thank you so much for becoming a YouTube member. Just Call Me Kim P has been a member for 2 months, everybody. Love Sunday Fun Day. Happy Crewversary. Michelle B just became a YouTube member. I love this. Everybody's clicking on the website. Southern CJB, happy crewversary, says, oh, hey, look at that. Officially over a year. Happy crewversary. Amy Pliskin just became a YouTube member. Thank you so much, Amy. Welcome aboard. WPB Phoenix says, JR, congratulations on the Clue Award nomination. Thank you. Your collaborations with other creators and interaction with your audience is exceptional. That is very kind of you, and appreciate those kind words. Yes, which brings me to the idea that CrimeCon is coming up end of this month. CDD wasn't able to tell us officially how many days, but it's coming up May 29th through 31st. Here's a couple of things. One, discount code. Tickets are still available. In fact, one-day passes are actually still available. So enter the discount code courtroom, all in caps, all one word, will get you 10% off. 2, we've got the t-shirts available now to everybody in black and white, available on the courtroomconfidential.com. And then 3, I am very proud to announce that I will be part of a panel that will be speaking at CrimeCon alongside Paul Morrow, Donna Rotuno, and Mike Ruiz from Fox Digital. We're going to be talking about the Nancy Guthrie case, the latest in that case. And we had, all of us spent a lot of time on the ground talking about our experience with the coverage of that case. And last but not least, we are very honored. We're blown away is the correct term for it, that we have been nominated for the People's Choice Creator of the Year Award at CrimeCon. So when you pick up your badge and you think of us, please send us a vote. We'd greatly appreciate it. Very fun stuff, and we're very honored because that award is chosen by all of you. So that touches us right squarely in the feels. Thank you, everybody. That's it. That's all I got. Big shout out and thank you to Greg Hartley from the behavior panel for helping us out with that question today. Appreciate you, my friend. Huge shout out and thank you to the best mod squad on YouTube. Afton, Sonia, Kathy, Therapist and Bess, Nancy, and Kaylin. Thank you so much for everything that you do. You are fantastic, and we appreciate you so much. And Tiffany, you are the best thing that ever happened to me. I will see you guys all here tomorrow night. Take care.